Thank you, sir. My apologies. 2 minutes.
2 minutes. Very good.
You.
Thank you.
This case stems from a motor vehicle collision between two individuals and involves two lawsuits regarding that collision. The first lawsuit was filed by Mr. Payne's client, Mr. Powers, Richard Powers, against my client, Mrs. Albers, for his injuries from that crash. That case was settled, and an order was entered dismissing that lawsuit and all of Mr. Powers' claims with prejudice. In that first case brought by Mr. Powers, neither Mrs. Albers nor her husband, Mr. Albers, brought any counterclaims whatsoever. Following the entry of that order dismissing Mr. Powers' case, I filed a lawsuit on behalf of Mrs. and Mr. Albers for the injuries caused to Mrs. Albers in the same collision. The trial court dismissed Mrs. Albers and Mr. Albers' claims relying on res judicata based on the order which dismissed Mr. Powers' case. It's our position that that was error for two reasons. Res judicata does not bar the Albers claims because they are tort claims, which are expressly exempted under 1301 of our rules of Tennessee Rules of Civil Procedure. Secondly, the Albers tort claims don't nullify the judgment in Mr. Powers' lawsuit. So the first prong of our analysis is just simply looking at the language, the plain language of 1301, which states that tort claims are express exemption to a compulsory counterclaim, meaning they are not required to be brought in the same by a defendant in an original action. Mrs. Powers was injured in the motor vehicle crash with Mr. Powers, and claims she brought in that lawsuit are injury claims, which are based in tort. The personal injury claims in that and her tort claims are exempted by 1301, and so.
Whenever you research res judicata, it always talks about claims that it includes claims that were brought and that could have been brought.
Yes,
now, just because the tort claims don't have to be brought doesn't mean they couldn't have been brought. So why doesn't res judicata cover that?
Because it would mean 1301 was rendered meaningless, Your Honor. 1301 would mean absolutely nothing if those claims were required to be brought in the same action. If that were the case, ultimately, all claims would be compulsory counterclaims if they arose from the same transaction or occurrence. I think that language is there for a specific reason, and the language is plain on its face. And so, the rest of the second part of the rule reads, if it arises out of the same transaction or occurrence, but immediately prior to that it says, except for tort claims. So it's our position that first of all, that applies. However, there's a second prong to the analysis, and that was...
Why is there exception for tort claims there?
Well, Your Honor, there is a comment from the legislature that specifies that the purpose of that is they didn't want to limit where that claim could be filed. However, that did not make it into the language of the actual rule. Our position is that the legislature want to make it immensely clear that it was that tort claims had to be filed unless they were choosing to file them in federal court. They could have made that express, and they did not.
Okay. So I'm having trouble following what you're saying. The purpose of the exemption for tort claims is due to possible venue issues?
Well, it was described as part of the legislative intent, Your Honor. It is not part of the rule.
Yeah, but every word is part of the legislative intent. But why are those words there? What is the legislative intent of those words other than a tort claim?
Well, I think, Your Honor, that the purpose of it is to not severely limit claims that a plaintiff or a defendant could bring otherwise when it involves a tort. It allows for that to be a broad possibility. So, the fact that it was expressly mentioned, we didn't want to limit it. If you file in actions filed in state court, and the defendant has the option to file in federal court or file something in state court, there's nothing in the language of the rule that says that action couldn't also be filed in state court and you could file your own action as long as it was based in tort. I think doing more reads beyond what the rule actually says.
Yeah, I'm not sure the rule actually says very much at all. It doesn't explain anything, but go ahead.
This was decided on a motion to dismiss, correct?
Yes, sir.
So how did the release get into the record here from the Powers case?
The release got into the record through the motion to dismiss, which was filed by the appellee in the matter.
Was there, normally a motion to dismiss is decided on the pleadings. Was there any objection to the court considering the release? Or I guess it sounds like your position is it really just doesn't matter.
Well, my position, Your Honor, was that the release would really only further explain what the agreed order of dismissal did, which is that...
I see. So you were comfortable with that release coming in because you felt like it bolstered your viewpoint.
Yes, Your Honor.
Okay.
It didn't have... It had no contractual obligations from my client to prevent them from bringing any action.
My first reaction to this case, though, is this seemed like more like a summary judgment type issue, and most res judicata is raised as summary judgment, but yet the court decided this on a motion to dismiss.
Yes, Your Honor. It was a little unusual circumstance. I've never encountered it personally.
With respect to Mr. Powers' initial case, had Mrs. Albers decided to defend against that, I'm assuming she would have asserted that Mr. Powers was more than 50% in fault at that case, correct?
Yes, Your Honor.
Okay, which is what she's doing in her current case.
Yes, Your Honor.
Yeah, okay.
And Your Honors, the second part of the analysis comes actually from another Court of Appeals decision, which is the Lowe's versus First City Bank of Rutherford County. And first they examined 1301. And the second part of their analysis was whether the successful prosecution of the plaintiff's claim in the second case would nullify an initial judgment or impair rights established in the initial action. But the agreed order of dismissal that was filed in the Mr. Powers action only establishes rights for the Albers. It expressly dismisses the claims brought by Mr. Powers. It doesn't address any claims by the Albers because no claims by the Albers were brought in that case. So the order is contained to the issues that were presented in that case. So taking the Lowe's analysis, that two-prong analysis, 1301 preserves tort claims, and no harm was placed to any rights established by the initial order in the initial case. Now, Mr. Powers has attempted to distinguish the Lowe's case by saying that the Lowe's claims were not compulsory counterclaims for two reasons. One, that they're tort claims, and two, that they don't arise from the same transaction or occurrence. But it is a failure to distinguish between necessity and sufficiency. In that instance, the court was saying there were two separate sufficient reasons why the Lowe's claims could not, were valid and could move forward. One was that they're tort claims, so they're already exempted, but also that it didn't arise from the same transaction or occurrence. So in this instance, that it's not necessary for this not to have arisen from the same transaction or occurrence because it's already exempted from that by 1301. That's what the Lowe's decision stands for. If it stands for a different proposition, it means that 1301 or other decisions by this court make tort claims compulsory counterclaims because they would have had to be brought in that prior case. There's a few other cases that were mentioned in the appellee's argument. First is Crane versus CRST Van Expedited. And Mr. Powers argues that Crane stands for the proposition that a party to a case can bring a separate action with claims involving the same occurrence as another suit, but runs the risk of a final judgment nullifying its rights. But Crane was dealing with compulsory counterclaims. The case makes it clear that the issues they were addressing were compulsory counterclaims in that case. So they were saying that you could bring a separate action on those compulsory counterclaims. However, if there was a judgment in regards to that initial case, you were out of luck.
Could Mr. Powers raise in his affirmative defense in Mrs. Albers and her husband's case comparative fault?
I believe he could, Your Honor.
Oh, really? How could he do that without violating the release he signed?
Because he's no longer making his own claim for personal injury. He's only.
But comparative fault is a form of claim, and it's any and all claims that he's releasing.
Your Honor, I'm not quite sure exactly how to reconcile that aspect of it. I think that the simplest explanation that I could give is the plaintiff still has to be able to plead her case, and in order to be able to plead her case, all the facts of that crash would come in, and a jury would get to apportion that fault. So the same opportunity would still apply in that instance.
But if Mr. Powers is not able to assert comparative fault, a jury wouldn't consider Miss Albers' fault in the accident. That would have been waived.
Yes, Your Honor.
So I'm trying to understand how it would work under your conception of res judicata. I mean, this case strikes me more as a collateral estoppel case and not so much res judicata, right? Because it's issue preclusion we're talking about, not claim preclusion.
It seems as though that's what we're talking about, and yet the entire case was dismissed on the basis of that agreed order of dismissal. So,
do we know who signed the agreed order of dismissal? Besides the judge?
I believe counsel for all the parties in that case. Your Honor,
Okay.
It was the Albers defense attorney as well as the plaintiff's attorney for Mr. Powers.
Okay. What about Mr. Powers himself? Did he sign it?
Not the order, Your Honor.
Okay, really? Okay.
Anything further? You can sum up, or?
Well, Your Honor, I've got 13 seconds. So
Sum up quickly.
Speak real fast like they do on TV commercials, car sales.
I would just simply say that, Your Honor, that there's that the agreed order of dismissal was purposed to prevent another lawsuit by Mr. Powers against Mrs. Albers on the same facts. That would be a proper application of that order so that he could not go back and sue her again. But to go beyond the scope of what's addressed in the order and also take away Ms. Albers' claims is clearly not anywhere within the scope of the order, and that's why we think it's error by the trial court. Thank you.
Thank
Your Honor.
Thank you, Mr. Lawrence. Now, I believe we have two appellees. Will you be sharing your time or just one?
I'll see 5 minutes.
Very good. So one, you'll have 10 and he'll have 5. Very good. Thank you. We're all ears.
Right. Good morning, Your Honors. May it please the court. I'm Taylor Payne. I represent Richard Powers in this case. And the law is pretty straightforward as far as res judicata is concerned. There's really 4 elements. You have to have a prior judgment on the merits. In this case, we have a agreed order of dismissal signed by Powers, Albers, and the unnamed defendant Dismissal with prejudice, that's on the
Okay, now you
merits.
say it's signed by Powers. It's signed by Mr. Powers?
It's signed by counsel who has authority to act
So-
on his behalf.
Well, not, according to our Supreme Court, that's not sufficient, right? I mean, there was a 1980 case, Garrett against Corey Form Products, that says that a dismissal with prejudice does not bind the client because the attorney doesn't have authority to bind a client to release of a claim.
But certainly the release would,
Yeah, the release, but I'm still puzzled how that even got in on a motion to dismiss. I thought a motion to dismiss was supposed to be on the allegations of the complaint alone.
only if it's 1206. Otherwise, you can bring in extraneous
Okay,
information.
and your position is this is a subject matter jurisdiction?
Yes, Your Honor.
Okay.
So therefore, other extraneous matters could be considered. The other element, of course, of res judicata is you have a court of competent jurisdiction. Interestingly, both of these cases were assigned to Part 5 of the Rutherford County Circuit Court. So same judge looked at both files.
And you're saying the circuit court doesn't have subject matter jurisdiction over a car accident case that happened in Rutherford County?
Well, that it did in the initial lawsuit, but res judicata bars all of those issues, all issues that could
Bars
have,
them as a matter of subject matter jurisdiction?
as a matter of law. Because at no point could the instant suit have been maintained while the prior suit was pending. So if the first lawsuit, Powers versus Albers, was pending and the instant suit was filed, a motion to dismiss on grounds of prior suit pending would have been appropriate and should have been granted. And then the counterclaim could have been brought in the Powers versus Albers case. And actually, that was raised in the motion to dismiss, both prior suit pending and res judicata. The court found that, essentially the argument was that there was 30 days had not elapsed from the entry of the agreed order of dismissal with prejudice, so the trial court still maintained authority to alter that judgment, or that order. The court disagreed there was no suit pending and granted the motion on the grounds of res judicata. And so just like the Crane case that we cite to, it's sort of interesting. So Crane sues CRST in Tennessee. CRST sues Crane on the same facts in Iowa. And this court notes that Mr. Crane never raised prior suit pending. He could have. He didn't respond to the Iowa suit. They take a judgment in Iowa, come back with a judgment to Tennessee, file a motion for summary judgment on the basis of res judicata, and the trial court grants it. And of course, this court sustains that or affirms that decision on the basis that, you know, if somehow you do have two suits pending on the same issue, and one of them goes to judgment first, well, then you lose your cause of action in the other case. And so at any point in time, if both of these suits were pending, first, this suit should have been dismissed on prior suit pending, and all matters and all claims should have been brought in the first case. If this suit was filed before the dismissal was entered in the first case, well, then, the first case went to judgment, well, then you could still have a res judicata argument because you'd have an agreed order of dismissal with prejudice. And all claims and cause of action are merged into that judgment. When we talk about res judicata, we talk about the same parties. It doesn't mean identical parties. It means substantially the same parties or their privies. And Ms. Albers was the defendant in the first lawsuit, never asserted any sort of counterclaim, and agreed to dismiss the lawsuit with prejudice. We talk about the same cause of action.
Well, wait, what about Michael Albers' participation in the second lawsuit? He wasn't involved in the first one.
But he's certainly a privy of Ms. Powers. He certainly had knowledge of the lawsuit. It's a loss of consortium claim. That's a different claim, but he's certainly...
That's a different claim than anybody else could have submitted, right?
Well, it still could have been brought in the first lawsuit. When we talk about...
He wasn't a party.
He still could have joined. He still had, I think, the knowledge of the lawsuit was imputed to him. And I mean, the issue here in this...
So you're saying a citizen out there needs to be aware of if friends and neighbors and relatives have filed lawsuits or been sued, that they need to be on notice that they need to jump in to assert a counterclaim?
Well, if they're involved with it.
Well, why they involved simply because they're a relative?
Because they had knowledge of the lawsuit. They had a claim that they could have
You can
asserted.
be the defendant in a lawsuit and have knowledge that you have been sued, and you can have knowledge that there's a summons out there and they're trying to serve you, but you don't have to run to court to say, please hand me my summons.
Well, at that point, though, actual knowledge is not you can't.
Yeah, but the fact that you have knowledge of a lawsuit or a claim, I don't see how that puts an affirmative duty on anybody who's not yet, for which the court does not yet have personal jurisdiction.
Well, they still have knowledge that they have rights they
Well,
could
that's fine,
assert.
but what difference does that make?
Well, because the law looks at, we don't want to have multiple inconsistent verdicts. We don't want to have multiple inconsistent judgments.
Well, that sounds all fine and dandy in a perfect world, but I don't see where that imposes a legal duty on anybody. And I don't follow your argument. I hear you saying something that in the best circumstances in our world, this would be nice if this happened, but I don't see there being a legal duty to race to the courthouse because a relative of mine has been sued.
Well, I guess I would assert that in this particular case, we can, of course, only consider what's in the record.
Well, that's what I'm considering. And
Well, right, and there's
what's in the record is that this person wasn't sued.
correct. But I think that the law would state that it's not identical parties, it's substantially same parties or they're privies. I think.
Why is this person a privy? A privy is somebody who's in the chain of title or is under a contractual obligation. The fact that you're a relative, I don't know why that makes you privy.
Well, I suppose that, a loss of consortium claim is a separate claim.
Now we're talking, okay.
But that takes us, I think, to the next element, which is we talk about the same cause of action. Tennessee recognizes the transactional approach of res judicata, so we talk about the same instance, the same occurrence. Everything has to be put together in that one lawsuit.
Well, that's a separate element, though.
That is a separate element.
So, we're really talking about the element of same parties.
Well, certainly, there's no dispute, I don't believe, that Lori Albers is an identical party in both lawsuits.
We're not talking about her either. We're talking about Michael.
Correct. I think that the law, and of course I'd be happy to submit a supplement, would look at Mr. Michael Albers and say, well, you should be diligent in determining whether this is going on. Certainly he was aware of it, considering it's her husband. I think that knowledge is imputed. But, the trial court found facts that support each element of res judicata. And I guess one thing we can address is the Rule 13 issue. I think that Rule 13 is separate from the doctrine of res judicata, which is separate from the doctrine of collateral estoppel. They're separate doctrines that they do have a similar effect, but essentially to adopt the plaintiff's position would be to say that res judicata just doesn't apply to tort claims, and that's certainly not the law. There is the discussion, the advisory committee discussion about the choice of venue, where tort claims are excluded so that if you can file, you may have a counterclaim that you can file in Rutherford County when there's a pending suit in Davidson County, and you don't want to deprive someone of that ability of choice of venue. In the instant case, it was a Rutherford County accident with Rutherford County residents. There's no choice of venue. It has to be filed in Rutherford County. So that issue, I don't suppose, even comes up.
So you're just so I'm clear, you're saying that the exclusion of tort claims in Rule 13 is because of choice of venue provisions in the general law, and that a tort claim could be brought in another county, legitimately be brought in another county, so it should not be viewed as a compulsory counterclaim.
Right, to the instant lawsuit. But certainly if it was the same.
As to same event and all that, res judicata could apply.
Correct.
If the elements are there.
Correct, and that sort of goes to the Crane case, where you have two separate lawsuits on the same issue, and one goes to judgment. Well, you can use the other judgment offensively, or I guess defensively in the first case, for the purposes of res judicata.
Let me turn back to the procedural posture here. Didn't you assert Jackson against Smith, the Tennessee Supreme Court case on res judicata, in your brief?
Jackson versus Smith?
Yeah, against Smith.
I can.
Okay, that's all right. I'm looking at that case, and it says res judicata is one of the affirmative defenses that must be included in the defendant's answer. However, in appropriate circumstances, it may be raised in a 12.026 motion. the motion just can be used as a vehicle to assert an affirmative defense. The applicability of the defense must clearly and unequivocally appear on the face of the complaint. That's our Supreme Court talking.
Well, if that's the case, I think we could look at the
So I guess the question is, in this case, does your res judicata defense appear clearly and unequivocally on the face of the complaint?
Well, I suppose that it doesn't. But I relied upon a case which said that res judicata can normally be raised by simply attaching a copy of the prior order.
I mean, it seems like to me the Supreme Court is probably where we should be going with our analysis, though, unless you feel like Jackson against Smith was decided incorrectly.
Well, I mean, if that's what the Supreme Court has said, certainly this court can't overrule that, I would not think.
All right, Mr. Payne, thank you for your argument.
Yes, thank you.
Mr. White?
Yes, Your Honor. Chris White of the Williamson County Bar here on behalf of Allstate Property and Casualty, which was served as the UM carrier under 56-7-1206. You've heard two really good lawyers talk about minutia in Rule 1301 and res judicata, and I'll field any questions related to that, but I was intrigued by some of the questions I heard. When Judge Bennett asked, why is this in here? Why this tort exclusion? It sort of ties in, I would respectfully assert, to the issue that statutes and rules, which are approved by the legislature, are to be construed in peri materia. And we have not only Rule 13 that says tort claims are not compulsory counterclaims. When that rule was promulgated and approved, the court presumably was aware that there was a statute that allows liability indemnitors, 55-12-122E3, to resolve cases on behalf of their insureds, unlike things like medical malpractice where the insured would have to consent. There is also a subsequent rule, Tennessee Rule of Evidence 408, that precludes furnishing or offering a settlement, whether in the present litigation or related information litigation, would not be admissible to prove liability or invalidity of damages. Taking all this together, you have a situation where sometimes economic realities cause an indemnitor to take a position, and if done for the right reason, not done in bad faith, then the insured would not be required to consent. And if that were the case, and Rule 1301 said that torts are compulsory counterclaims, every liability insurer that ever settles a case better have a signed acceptance of that right from the insured. And if not, then you'll have even more extra-contractual litigation than sometimes already exists.
What you're referring to then is the release.
The release and the order, which were executed simultaneously.
Okay. And so how does the release get into this?
Into this record? I would respectfully submit it has no purpose in this record at this point in time on this Rule 12 motion.
Then how do we, addressing what Judge McBrayer mentioned, that an order that includes the signature of counsel for a party but not the party, how do we get by the Supreme Court decision that cannot be binding upon the party?
I agree with the inference of the question that this is not the good case for res judicata. I'm in the unusual position as an appellee of disagreeing with my fellow appellee. I believe the case should be reversed and remanded to the trial court for further proceedings. In response to Judge McBrayer's question about how could Mr. Powers assert comparative fault, under Rule 12, that is listed as one of the potential affirmative defenses, and it is not unusual for people to assert comparative fault in the appropriate case, even though they opt not to assert a counterclaim. Now, but for the rule language in 1301, they would have to use it or lose it. But with that language, they would be able
Yeah,
to.
but I guess if I'm Mr. Powers and I've signed this release, I would be very, or at least if I was an attorney advising Mr. Powers, I would tell him, look, there might be some concerns here that they're going to allege that you are in breach of the release agreement you signed, because the language, I mean, it's very specific in the entry paragraphs of the release, but then there's a paragraph at the very end, I think, of the release language that says, to remove all doubt, any claim that can be asserted, and I don't know how you couldn't make a good faith argument that a claim that, Ms. Albers, you are more at fault, violates that provision. I mean,
I would respectfully submit that under Tennessee Rule of Evidence 408, that document never sees the light of day in Albers versus Powers, for the very reason
well, that's
you
going to be
suggest.
cold comfort to Mr. Powers when he's separately sued for breach of contract.
Is there consideration? I guess there would be consideration for that.
Yeah,
The
I mean,
dismissal
he's-
of lawsuit.
Yeah, right, dismissed his lawsuit, got paid money, and then said, I'm releasing all claims and avoid any doubt, any claim that I might have.
Well, I confess I have not contemplated that piece of it. I've thought of all kinds of
Yeah, I'm just
illogical things
worried
that
if-
could happen
if-
given my fellow appellee's
Yeah,
position, but I
Yeah,
would.
just concerned if the plaintiff in your position is right here, Mr. Powers has got himself in a jam by signing this release. He should have asked for a mutual release, I guess, but.
Or wanted that language stricken. Thank you for your time.
Thank you, Mr. White. We'll hear rebuttal from Mr. Lawrence.
Thank you, Your Honors. And I did want to address one of the points by the defendant in regards to whether the appellants believe in that res judicata applies to tort claims. We do. We just believe in this case it applies to Mr. Powers' tort claims. That was the exact issue that was addressed in Hawkins, where a plaintiff attempted to piecemeal his claims, and that was one of the cases that was cited by the appellee in his brief, where the plaintiff in that case brought part of his claims all the way to a judgment, and then he decided he had some more, and he wanted to bring those additionally. Res judicata applied to that because he had the opportunity to bring all those claims when he brought his tort claim. We certainly don't dispute that, but we think simply that proves the fact that only Mr. Powers' claims are prohibited from moving forward. Our clients did not bring any personal injury claims or tort claims in that first action.
Anything further?
No, thank you, Your
All
Honors.
right. Thank you, Mr. Lawrence and Mr. Payne and Mr. White, for your arguments. We'll take this matter under advisement.